My name is Philip Berkowitz. I'm with Littler. Littler is the largest employment law firm in the United States, and we are also all over the world. The office we opened most recently is in Singapore, so we're now officially in Asia. Very happy to be here today. Just want to, as you all join and get settled, please note that there is a poll that we'd love for you to fill out, and we'll share the results at the end of the program. So I'm very thrilled to have the opportunity to be speaking with you today. We are sponsored, of course, by our good friends at the China General Chamber of Commerce, and really appreciate this opportunity. My colleagues with me are Devjani Mishra. Devjani is an extraordinary, well-experienced lawyer. You'll hear when she begins to speak, and has basically been living with this whole COVID situation for the last year, advising our clients, and has become totally immersed in these issues and is a real go-to person for all of these issues. Melissa Peters is fantastic as well. Melissa is in our OSHA team, but she has been devoting herself as well for the last year or so to the numerous occupational safety and health issues that arise out of COVID. And so she is an extraordinary resource, and it's amazing the team that we have put together at Littler dealing with these issues. Let me close this poll so that you can see these lovely photos. I hope that was okay. You had your chance to fill out that poll. And I think what we should do is get started. So let's, if you don't mind, I'm going to be asking our friend Hallie at the China General Chamber of Commerce to advance the slides for us. So Hallie, can you please go to the next slide? We'll get started. So anyway, here's our agenda. We're going to be talking about, we have about an hour and 15 minutes, if I'm not mistaken. We are going to try to leave time for questions at the end. We are going to be rushing through these issues. There are so many issues to discuss, but you will be able to have access to these slides afterwards. And there's just so much that we're going to cover. And anyway, we're going to start with business restructuring. We're going to talk about workforce reductions, the WARN Act, and other issues, and also reversing or scaling back changes that were necessary. Devjani is going to cover that issue. Devjani is going to cover the work from home and return to work issues, and sharing that with Melissa. And in particular, I think Melissa is going to address the safety requirements and government inspections, which have been coming up quite frequently for many companies and many clients. We suddenly find audits and the government walking into our workplaces. And then the key issues on avoiding discrimination, which I think Devjani and I are going to both cover. And so there's a lot of information out there about discrimination and potential discrimination issues, principally dealing with disability and age discrimination. But let's move forward so we can just dive in. I'm going to cover workforce reductions. So please go to the next slide. Hallie, let's go to the one more. Thanks. Okay, so before we get to a workforce reduction, you know, sometimes we want to think about, can this be avoided? And you know, by the way, we talk about workforce reductions. There are different words for it. We sometimes call it a reduction in force, a RIF. We sometimes call it a layoff, although a layoff often, you know, is interpreted as being for a temporary period of time. So we may use these terms interchangeably. But again, before we get to a RIF, we might want to think, well, how can we avoid it? And I guess that this has been an issue we've been dealing with, many of us, for the last year, particularly when it all started. We thought about furloughs, you know, which were, you know, we'll let you go for some period of months and maybe we'll be able to bring you back, until we had a sense of how long this whole thing was going to last. And now, unfortunately, well, we've been seeing workforce reductions throughout this event, but we're seeing, I think, more now. We're just seeing quite a bit. And even as we are thinking about coming back, but we're not quite there yet. And of course, many jobs, in particular those relating to facilities, have gone away, and yet companies have been keeping people and paying them, and a lot of companies are starting to think, well, how long can we really keep that up? So there are different ways to avoid a workforce reduction. They're spelled out on the screen here. Some of them are voluntary. We ask people to volunteer, but that can be a challenging and not a really good result because we don't control who leaves, and we may lose employees who are most valued. Hallie, let's go to the next slide. Okay, so the first issue, assuming we can't avoid a workforce reduction, is often the WARN Act. Many of you, most of you have probably heard about the WARN Act. The WARN Act is a federal law, and then we also have what are called mini WARN Acts, which are state laws. The WARN Act, both of these laws require employers to give employees advance notice of termination. In the case of the federal WARN Act, it's 60 days. Some states, again, not all states, but these mini WARN Acts may provide more notice. So New York, for example, requires 90 days notice. WARN Act applies to larger employers. The state mini WARN Act will usually capture smaller employers as well. And the WARN Act is just a very complex statute. I'm going to cover some of the highlights here, but you really need to consider this, because if you fail to give the 60 days notice, then you're liable, or the 90 days notice, you're liable for the back pay. You can be liable for attorney's fees, and we're seeing more and more of these cases being brought as class actions. And so the liabilities can be very high. Next slide, please. So the WARN Act applies to different circumstances, a plant closing or a mass layoff. Again, these are defined terms. It's a complex statute. I'm not going to go into all the details. We don't have enough time, but it applies to different circumstances when there's a plant closing or a mass layoff. And again, it is defined differently, and it depends on how many sites we're talking about, a single site or numerous sites, where these sites are they within a certain mileage of each other? And so there are numerous issues to think about when we're dealing with whether WARN Act applies, and we need to be very careful. Next slide, please. So as I mentioned, the issue may entail not only a single site, but it may include buildings in a reasonable geographic proximity. And so there are different complicated issues in determining whether the WARN Act will apply to you, how to count the number of employees. So we need to consider that. If you're spread out around New York City, you may have, even if there aren't enough employees in one site, you might have to count all of them. Even, if they're in Newark or New York City and so forth, you need to be careful and not conclude it doesn't apply. Next slide, please. And again, there are many rules regarding the WARN Act. They apply to temporary employees, of course, full-time, temporary employees. And then there are questions, well, might it apply to temp agency employees? And generally it does not when the agency employee understands the temporary nature of their job when they're hired. And there are complex rules regarding part-time employees. They're not counted to determine whether a WARN event is occurring, but they are due to receive notice if you're going to give advance notice. So different rules, different employees, and also joint employer issues. You may not think you're the employer of an individual, but you might be considered one under the law, depending on the amount of supervision you provide and so forth, the usual tests. Hallie, next slide. Here's a real tricky thing about the WARN Act, and this is what came up during the last year. The WARN Act headcount deals with what we call rolling time periods. And so you're going to look to see how many people were terminated in any rolling 30-day period. However, if two or more groups suffer an employment loss, as we say here on our slide, at a single site within 90 days, and none of these groups is large enough by itself to trigger the WARN obligation, then those groups will be aggregated together. So you might think that you don't have so many people, and in the first round, you may not have enough. But if within 90 days, we end up terminating enough to get to that threshold number of employees, depending on whether it's a plant closing or a layoff, then you might have to aggregate those and give notice at that time. So the employer always needs to be thinking about, what am I going to be doing in 90 days? And what have I done in the past 90 days in order to determine whether WARN notice has to be provided? Next slide, please. There are some exceptions to the WARN Act, and they deal with, generally speaking, whether the circumstances were foreseeable. There's an unforeseeable business circumstance exception. There is a faltering company circumstance where you're looking for capital and didn't really expect you'd have to close down, where there's a natural disaster. So you may be excused from providing notice, but then once it becomes clear, then you're going to have to give notice as soon as practicable. And by the way, the notice goes not only to the employees, but it also goes to government officials, and it also goes, if there's a union involved, to the union officials. So there are different entities to whom we have to give the notice. Let's go to the next slide, please. Okay, so we have now dealt with WARN in as much detail as we're going to in this program. And that may have been the quickest WARN presentation on record. But again, it's a statute where if you anticipate an issue, you really need to speak to counsel. But what happens in addition to WARN? The WARN is almost, I don't want to say it's the easy part, but it's where we need to provide notice. But then the question is, and the very important question is, how do we structure the workforce reduction? How do we do it in a way that best protects the employer? This also is complex. And again, while there is not enough time to give a full discussion, I am going to give a highlight of the best practices in going forward with a workforce reduction. Hallie, next slide, please. Okay, so here's our favorite chart of showing who is protected by our various discrimination laws. We've got federal laws, we have state laws, we have city laws. And so the employment at will, of course, as you all know, means that it's okay to terminate employment at any time with or without notice and with or without cause, unless the reason is discriminatory or illegal in some way. And generally, illegal in the US means discriminatory. And these laws apply in the case of workforce reductions, just as they do in the case of individual terminations. And you know how much time we take to determine whether we're violating the law in an individual termination. We need to give similar kind of scrutiny when we're terminating a large group of people. Obviously, we're not necessarily relying only on, say, job performance when we're terminating people as part of a RIF. And so the scrutiny may be a little bit less intense. But nevertheless, we have to anticipate that individuals may bring a discrimination claim as a result of a RIF, and this could even be as a class action. And so that is a significant risk, usually focusing on age discrimination or gender discrimination or disability or whistleblowers. Next slide, please. So, and we're all familiar with the different kinds of discrimination. All of these apply. And as I said before, sometimes we end up, a manager comes back and wants to terminate the people in their team, and they've chosen all the older people. They've chosen somebody who's been on a leave of absence because of a pregnancy. They've chosen somebody who's made complaints as a whistleblower. We need to be very careful when we are seeing these decisions and considering whether those decisions are appropriate. And so before a decision is finalized, it's important to scrutinize these decisions to be sure that there is not going to be a claim of discrimination, or if it does appear that there's a potential for a claim, at least that you know why they're making that decision and that you have a good reason for it. Let's go to the next slide, please. So it is important to identify when we're planning for a RIF, we need to explain, why is it happening? First of all, are we getting out of a product or service line? Has COVID caused there to be less of a demand for certain services? Has COVID ended up, causing, as I said before, maybe we don't need our facilities team quite as much. Maybe there are certain jobs that we don't need. We've done without for the last year. And so identifying that reason up front is important, and helping to explain it in writing so that we have evidence in advance that explains the reasons for the workforce reduction. Because if there is a lawsuit, in the U.S., there are no secrets. Everything is going to be disclosed in discovery. So we need to be clear and articulate in documents why these decisions are being made and the business justification for doing it. Next slide, please. So the documentation should show how we are choosing the employees to terminate. And there are different ways of doing it. We could just leave it to the discretion of managers. But again, as you can imagine, that is very risky. There's a risk of bias, conscious or unconscious. Last in, first out is an unbiased way of doing it, but you might lose your most recent hires, your minorities. Forced ranking, how do you come up with a forced ranking system? That can be very challenging. How do you determine your best performers? That can also be challenging based upon outdated performance evaluations. So there are many different ways of doing this, but however you do it, it's important to document the choices, show that it's fair, articulate the non-discriminatory reasons for the decisions, and also make clear to managers up front that in making these choices, they must not consider discriminatory, unlawful criteria such as age or pregnancy and so forth, that the company prohibits discrimination in all circumstances, just as it does here. And so you want to paper that very thoroughly in advance. Next slide, please. And as I mentioned, as we all know, there are no secrets in a U.S. lawsuit. And that is why, and it is important to get legal assistance when you are conducting a workforce reduction. You can do it in that way in the context of a privileged communication. The lawyers can help you review the decisions. The lawyers can even help you with statistical analyses or engaging a third party to conduct a statistical analysis. The lawyers can help you reviewing the information, helping you formulate questions for managers, and all of that can be done in a manner that should be privileged and confidential, unless the privilege, of course, is waived. But that is the best way to do it. And then, of course, we can structure the documentation, help you structure the documentation that we do expect will be discovered and will help explain the reasons for it. Next slide, please. It's important also to remember communication is critical in a workforce reduction. Communicating to employees and communicating to non-employees, communicating to third parties, to people who are selected for the workforce reduction and the remaining employees. So we want to be perceived as fair. We want to be fair. We want to be perceived as fair. And we need to send a message in a way that lets everybody know that this has been a process that, of course, nobody wanted to go through, that we regret, but that was necessary. It was as fair as possible, and that the company has developed a course of conduct for treating the people who are affected in a fair way. And you have to think about public relations here, and you might even want to think about retaining a PR firm sometimes, depending on the size of this. Next slide, please. Of course, there may also be security concerns, workplace violence concerns. We have to take that seriously. You need to consider, again, consulting with counsel or counselors. Next slide, please. And then the key issue here, of course, is when we terminate people, we often provide them with a severance benefit. It is legal in the United States. Severance is not mandated by the law unless you have an employment agreement, but it is legal to pay severance and require employees to sign a release of claims in exchange. Drafting the releases is very tricky and is something, again, that you will need counsel to assist you with, because the law concerning releases and the legality of releases changes all the time. Releases change all the time because the law changes all the time. You also need to think about, by the way, does the employee have a non-compete or a non-disclosure or confidentiality agreement? You may want to preserve those and say that they continue to be in effect. You might want to attach them as an exhibit, or you might waive enforcement of some of them. Again, important to think those things through. Next slide, please. I think the biggest issue when it comes to these agreements, the severance agreements, is that when you're dealing with employees over age 40 and over, they have special protection. And so the releases must give those individuals, if there's a group, we have to provide them with 45 days to review the release. They then have 7 days once they have signed the release. If they choose to sign it, they can revoke it within 7 days. Critically, it is important when there's a group termination to provide employees with information concerning the individuals who have been chosen and the individuals who have not been chosen. We have to provide their ages and their job titles. We have to provide a list of employees to each release of individuals who are age 40 or over, providing the job titles and ages of those people who are in their, quote, decisional unit, which again is a complex issue which we can help guide you through. If we don't do it right, I mean, if the severance agreements don't provide the correct information, then the release of age discrimination claims will not be enforced. Next slide. You also need to think about, finally, this is my last slide actually, we need to think about unions and contracts. Is there a union contract? If there is, then there are different obligations, additional obligations that may apply. Are there other kinds of agreements in place between employees and the employer? Are there provisions in the handbook we need to look at? So we need to think about not only the statutory discrimination laws, but also what contracts are in place. And with that, I'm going to hand things over to Devjani, who's going to talk about business restructuring initially. Thank you, Devjani.
Thanks, Phil, and thanks so much to all of you for joining us. I think one of the things that that isn't listed as the COVID challenge, but definitely all of our clients have been experiencing it. Many of you may have been as well. There are so many requirements changing so frequently that really at this point, Phil and Melissa and I have done a lot of these webinars together, and I think probably the challenge we could always begin with is that there's just so much content to get through. So we appreciate that we're giving you an unfairly high amount of information. We encourage you to submit questions and we'll try to get to them if we can. Just in terms of this piece, Phil's told you quite a lot about business restructuring already, but if we could go to the next slide, Hallie, I just want to talk about a couple of issues here that are specific to COVID. One of those is it's been about a year, and a lot of businesses made some changes pretty quickly as restrictions were happening, as economic circumstances were changing very quickly, and so it's always a good time to just review as you're thinking about returning to the office, returning to normal operations. Do a review of what you did and what maybe it's time to undo. That may include furloughs or layoffs if you let go part of your business on a permanent or temporary basis. It may be reversing some pay reductions, deferrals, changes to working time. Perhaps there were changes to incentive pay or to benefits because people were working differently or certain things were no longer needed. So reviewing all of those steps, it's a good time to do that. And again, as Phil mentioned, it's important to work with counsel to anticipate any issues that might arise as you're reversing some of the changes you made. Next slide, please, Hallie. As you're recalling furloughed employees, just make sure that you are identifying objective business-based criteria, what the order for the recall will be, and thinking through why those people who are being recalled are needed by the business at this time and why others might not be until later. Keep communications open for those who are staying in furlough status if you're intending to hold them there. So much of what we do, it's a little secret, we don't always tell you this, it's not really about the legal issue, it's really because communications with an employee have failed and they're frustrated. And to the extent that you can communicate clearly and transparently what's going on, that can go a long way to mitigating your risk. Next slide. The other thing that many businesses are thinking about right now is structures that may need to change for the long term. Things that we had more or less taken for granted going into 2020, and given the changes to our businesses, we need to rethink. That may be your production-based compensation. It may be the way that performance goals are set. I don't know anyone who accurately figured out in January of 2020 what their performance goals should be. If there is that person, they're probably off in another line of work, which is quite profitable, which is predicting the future. You'll want to think about continuing external effects on compensation. Many of you have international operations. We can already see that different parts of the global economy will come back in different ways at different times, whether it's changes in interaction, whether it's changes in travel plans, supply chain effects. There may be continuing external factors that you need to think about. And there may be specific locations that are going to continue to be affected by COVID even as things start to come back in some locations here. Moving on, we wanted to make sure that we had enough time to talk about this next issue. Next slide, please, which is leaves of absence. This is something that is, sort of unique to the way that we've responded to COVID here in the U.S. We don't have, unlike other countries, a national form of paid leave. And so despite the fact that it's a pandemic, despite the fact that it's important to get sick employees out of the workplace, we have sort of a hodgepodge of different approaches to the issue. Next slide, please. The main federal response that we had to COVID in the United States was something called the Families First Coronavirus Response Act. This was federal legislation that was passed as of April 2020, and this was really the first and only time that the federal government in the U.S. has considered any form of paid leave for employees as opposed to unpaid leave. Now, what's strange about this legislation is that it only applies to companies with fewer than 500 employees. And when asked, why is this the case? The answer seemed to be something like, we assume that larger employers, anyone with more than 500 employees, already has this figured out. Without disclosing any confidences, I can tell you there are many larger employers that did not have this all figured out and that have really struggled to come up with what the next or what the best way of dealing with paid leave should be. But what this legislation did originally was require employers to extend certain types of leave, paid sick leave for employees who themselves were sick or potentially sick or trying to get treatment for COVID, as well as paid family leave of up to 10 weeks for employees dealing with school closings. You can tell looking at those periods of time, this legislation really did not consider the possibility that COVID-19 would be something that we'd be dealing with after the end of 2020. The law essentially was only mandatory through the end of the year, and then it was extended for those employers who voluntarily wanted to extend it through March 31st. The way that this works is to provide tax credits to employers at this point who are choosing to provide this leave to their employees. There's now been an extension with the stimulus legislation that was signed last week so that employers can again choose to extend leave under this act through September 30th, 2021. Also, as of April 1st, the time that's needed to get the COVID vaccine will be a covered reason to take leave under this act. But really, this has been a very partial response. There's a lot of employers who are not covered by it. There are a lot of smaller employers who struggle with it. So this has been the main federal response, and I think it remains to be seen what will happen if we get to September 30th and the pandemic is not resolved, which many people would be smart to believe is the case. Next slide, please. So, what most employers have to deal with is a combination of various state and local leave laws. And there's a number of different categories of this. There's paid sick and safe leave laws, which we have in New York and various states in the Northeast, in California and around the country. These are for providing limited sick leave to employees who themselves are sick. There are paid family leave laws. These allow employees to take leave for the care of others who may be sick. There's what are called FELOs, Public Health Emergency Leave Ordinances. This is a category that's very popular in California. And then there are special COVID sick leave laws that are for use for COVID only. New York has one of those. There's not enough time really in a week to go through each of these in detail. There's basically dozens of them all over the country with slightly different rules. But the basic points to know about these is that many of them are either new during the COVID crisis, or were only a few years old at the time that it started. And so the law under them is continuing to develop. To the extent that you have a leave of absence policy for your whole workforce, it may or may not be sufficient to deal with all of these new pieces of legislation. They're adopted all the time, they change all the time. So it's important to be constantly checking your policy against the different requirements where you operate. And if you have operations in, say, New York and California and Washington State, for the sake of argument, you may have three entirely different sets of rules that your employees would have to or would be eligible for, and you'll have to figure out which ones come into play for any given employee's leave of absence. There are different rules about how the leave accrues when employees are eligible to take it. Unlike federal law, which typically an employee has to be working for a company for a year in order to become eligible for leave, many of these laws kick in just when an employee is hired. And so your policies may not have accounted for that. But again, it's important to note all of the agencies that enforce in this area view giving time off to employees as a safety measure. If someone is symptomatic for COVID or a contagious disease, the expectation is that the employer is going to get them out of the workplace. And so, these are all considerations for every employer to look at. Even if you have the best HR and leave of absence team, they could be forgiven for being really tired after a year of managing all these requirements. Next slide, please. So then we get to the topic that everyone has really wanted to talk about the most, going back to December. And we're lucky to have a team of about 50 lawyers that have just been working on vaccination-related issues and have been working with a lot of clients on the issues that they're seeing. So next slide, please. As you probably know, regardless of where you are listening to us from, we have a very, again, unusual response to COVID in that a lot has been left to the individual states. And in this case, the federal government is allocating vaccine doses, COVID-19 vaccine doses, to different states and some localities based on the population that lives in those states and localities. However, it's then up to the states to decide who's eligible and on what schedule. And the approaches to eligibility have varied widely. In some states, they are more or less following the CDC guidance about which categories of individuals should be eligible. In other states, they are prioritizing certain types of certain employees based on the type of work they do. In still other states like Connecticut, where I happen to be, they are prioritizing just based on age. And so it can be a real question, again, if you have employees in different states, which parts of your workforce will be eligible for the vaccine at different times. Just recently, the federal administration has directed that states should make all adults eligible for the vaccine by May 1st. When people will actually get the vaccine is a different question, but the states have been directed to come up with plans so that everyone would at least be eligible to make their appointments by May 1st. Again, we have a working group here. We have on our public part of our website this survey, which is collecting the information regarding different plans in different states and who's eligible in which state. I encourage you to consult that. It changes multiple times a day. Next slide, please. So the big question that really we've seen many variations of going back to December is whether employers can mandate, that is, can require that employees get vaccinated as a condition of employment. And many people have asked the question in the basic form of, can employees be required, or can employees be terminated if they don't get the vaccine? We don't really find that an interesting question. We have spent a lot of time engaging with employers on the question of, if you mandate or if you recommend, what are the steps that you should be taking for that program to be successful? What are the considerations that should inform that decision for you? Because it's always one thing to say that you can do something, it's another thing to say that you should do that. And so the way that we look at this is that for every employer, you've got to be thinking through a number of different issues. There are the logistical issues. Is the vaccine even available to my workforce? If it's not available, there's no point in mandating it. It's a requirement that your employees are not going to be able to meet. If it's not easily gettable, employees will try to get it. They'll be frustrated, and that's a bad situation as well. We need to be thinking through public health policy, the ongoing federal transition in this area. What priorities have been set for the vaccine have changed multiple times over time. Early on, a decision was made to prioritize individuals over the age of 65. There's a lot of good reasons for that decision, but what that meant is that it made most employers irrelevant to the process, because most employers do not have a lot of employees over the age of 65. And so a lot of employers who were really ready to get involved in this found themselves somewhat sidelined for a period of time. There are community considerations to think about in terms of whether mandating the vaccine will get you the results that you want. If your schools are still closed, or the schools your employees' children attend are still closed, if public transportation is not open yet, that may be something that influences whether mandating the vaccine makes sense. And finally, there are going to be different legal and employee relations considerations affecting each workforce. And those are really some of the things that you need to be thinking through. Next slide. So in terms of legal considerations related to the vaccine, moving to the next slide. The main thing to really be considering here is the EEOC guidance. There's really just one agency that has taken a position about mandatory vaccinations in the US, and that is the EEOC, which has said that employers can mandate the vaccine at the point where the vaccine is available to members of its workforce, but that it needs to make accommodation for individuals who have either who are medically unable to take the vaccine for a variety of reasons, or who have a sincerely held religious belief that causes them to object to taking the vaccine. And in either case, the assumption is that the employer is going to work to identify a reasonable accommodation that allows that employee to work despite the fact that they cannot take the vaccine. Simply excluding people from the workplace is considered a very last resort. The assumption for now is that individuals will continue to work under COVID safety protocols. And Melissa is going to talk more about what those are. But right now, we're still looking for data on whether the vaccine prevents transmission. So we know it's great at preventing individuals from getting sick themselves or from having serious health consequences. What we don't know really is the extent to which it keeps someone from being able to transmit the virus to someone else. And so the assumption for the time being, until we get more public health guidance about this, is that you're going to keep wearing masks, you're going to keep working under protocols. What does that mean for employees who aren't vaccinated? Well, they can keep working. If they're not working remotely, if they're returning to the workplace, the assumption is that they're going to keep doing those things. It's going to be hard for an employer to say that, that's not a reasonable way to deal with someone who's unable to be vaccinated. Moving to the next slide. So we also get a lot of questions about third-party implications, and particularly, what if a customer is requesting that our employees be vaccinated, or what if I'm a contractor to someone else and my customers requiring me to be vaccinated, or can we require our contractors who don't work for us to be vaccinated? Basically, if you're going to have a requirement for your own employees, it makes sense that you would also impose a requirement on others who are regularly working in your business. We always say COVID does not know whether you're an employee or an independent contractor. It doesn't know your tax status. It simply knows that you're a human being. And it infects people without regard to how they've been employed or what kind of taxes they're paying. So, if we get to a point where the vaccine is widely available, it may become commercially reasonable for people to impose this kind of requirement and say, our contractors also need to be vaccinated, or, I will only deal with employees of yours who have been vaccinated. And so in those circumstances, you're going to have to think through, how access to the vaccine is facilitated, what kinds of privacy rules are in place, because you may not have the same rights to ask about the vaccine for individuals you don't directly employ. You have to think about how to maintain the confidentiality of your own employees if you are making representations about their vaccination status to others. It's a complex area. But right now, we're getting these questions. People are anticipating that down the line, there is going to come a point where people are making commercial decisions based on the percentage of their business partners who've been vaccinated. So those are issues to think through. Next slide, please. Wage and hour issues. This is, again, something that could take an hour to get through, and we're not going to give it the time that it needs. But one big question is, must an employer pay for the time spent getting a vaccine? And this is something that changes all the time. It changed just this week in New York. The basic framework is if an employer is going to require that its employees be vaccinated, it should assume that it's going to have to pay hourly employees for the time that it takes to get that vaccine, because it's a requirement of employment. If an employer is not requiring that the employees get vaccinated, it may still be a good idea to address this issue, because we are looking for ways to encourage people to get vaccinated. Again, in New York, just this week, the legislature added a requirement that employees have to be given 4 hours of paid leave, or up to 4 hours of paid leave per injection, in order to get the vaccination. The thinking being that this is something that removes a common obstacle for employees who are not able to get appointments for the vaccine outside working hours. So this is one to watch and think through in terms of what will happen if you choose to mandate. Next slide, please. This may not be an issue that affects many of you, but to the extent that you are in a union environment, you may need to consult with your unions about whether you can mandate the vaccine. If you're going to be imposing consequences on employees for not getting the vaccine, that is something that unions are going to have an opinion about, and you need to be prepared to have those conversations. Next slide, please. Another, again, possibly unique issue here in the US is that we have a significant portion of the population that is anti-vaccination or anti-vax. And so there is concern about resistance or hesitancy to getting the vaccine. There is the possibility that individuals who are not otherwise protected, that is, they don't have a disability reason, they don't have a religious reason for objecting to the vaccine, may nonetheless act collectively to protest mandatory vaccination. And this is an area to watch. It may have a large effect on whether the vaccine really opens things up for us. Next slide, please. So the reality for most employers is they just have to think through that, the way the vaccination has been rolling out, it's going to segment your workforce. Different categories of workers are going to be eligible at different times and have been eligible at different times, depending on where they live, how old they are, whether they have other health conditions, whether they have to work in person on the front line or can work remotely, and how risky their work is. We're also seeing that different demographics are affecting people differently in terms of their willingness to get the vaccine. And we know that there can be access issues in terms of whether people can get the vaccine. Next slide. So, the key takeaway in terms of what you can be doing is really thinking through, who is going to be eligible when? What are the things we can do as an employer to support the public health effort? How can we make sure that our employees are not going to be surprised by costs? Sometimes people are getting hit with appointment fees and other kinds of fees related to getting the vaccine. To the extent you can remove those, that would be helpful. Thinking through what you're going to do for your hourly paid employees, and really just in total, developing some positive and specific and fact-based messaging around the vaccine to encourage people to get it, because there really is nothing more important to our ability to end the effects that this pandemic has had. Moving on to the next slide. And with that, I'm going to turn it over to Melissa to talk about this still extremely important issue of safety requirements and government inspections. Melissa?
So basically, both the regulations and orders employers are required to follow, and the level of government inspection activity is determined by jurisdictions where a company is located in the U.S. Of course, many employers have multiple locations in a single state or country. Excuse me, sorry, I had some technological issues. It's better now. So it's really important that you stay on top of local regulations in areas where you have facilities or work sites, because if there's one thing we've all learned in the past year, it's that safety requirements change regularly based on case numbers. As we know, certain jurisdictions are much more conservative in terms of employer regulation than other jurisdictions and localities. And as a rule, those states, counties, and even cities that impose more onerous safety obligations on employers are generally the same locations that have a very active government inspection activity. So OSHA recommendations. In many OSHA state plan states, OSHA has enacted requirements for employers mandating that they implement COVID protection programs, a CPP. So even if it's not mandated in the jurisdiction where you are located, it's recommended by OSHA that all employers implement an effective CPP. And from an OSHA liability perspective, it's a good idea to do this. Of course, we're all waiting for the federal OSHA ETS, the Emergency Temporary Standard, to come down that was anticipated to be released yesterday, but to date, as of 2:49 p.m. Eastern Time, it has not been released. Once it is, it will be very important to work with your outside counsel to understand what you are required to do to comply with that ETS in locations where you are situated that are under federal OSHA jurisdiction. It's really important to figure out who's going to be in charge of implementing safety protocols. In order to have an effective safety program, you have to assign a responsible workplace safety coordinator. Part of that effective program is also establishing a system for communicating with workers. If you can't communicate requirements of a program, it doesn't matter how great the program is in written form on a piece of paper. If workers don't understand what they're supposed to do to be safe, your program is going to fail. So this is also really important to educate and train workers on COVID-19 in a format that's accessible to them. When you have issues with people that don't speak English as a first language, you have to take that into consideration. It's really important. Also, provide guidance on screening and testing. Even where testing and screening is not required in those jurisdictions, it's going to encourage employees and make it easier for them. They're going to be more likely to do these things, to go get tested, to conduct self-screening, if it's made easy for them and if they understand the benefits of doing so. Of course, it's very important to record and report work-related infections. We know as a trend, OSHA is issuing most of its citations in this category for failure to report for work-related violations that arise from hospitalizations and fatalities. Again, as Devjani mentioned, don't distinguish between those who are vaccinated and not. COVID enforcement trends. There are in-person and virtual inspections that are occurring. And I know one of the issues some of the clients that I work with were having was that they didn't know that an inspection was being opened because the OSHA investigator conducted what is known as an opening conference over the phone instead of in person at an employer site. So it's really important to ask questions about what is happening if you receive a call from a government inspector. Most citations, like I said, have been issued for record-keeping violations. So make sure you understand that. The healthcare and home care industries have been hit really hard with respiratory protection violations. Of course, OSHA has issued general duty clause citations in a few instances. And in California, that has the ETS, which came out in the end of November, employers are required to test. So that is something that California employers are being cited for now. And of course, we have the Department of Public Health with sort of, publicizing and publicly shaming employers that have been cited for COVID-19 concerns. In my recent interactions with various county health departments, the case managers I speak with are all pretty much saying the same thing, which is their goal for the inspection is to figure out where the transmission occurred. So anytime you have a health inspector come in, whether it's from OSHA or DPH, be cooperative. It's okay to ask questions, but it's important that they understand that you want to work with them. The last thing you want is an angry inspector who thinks you're trying to block them from doing their job. Of course, really important to determine the scope of the inspection. The scope of the inspection, or the basis of the allegations, it is what is going to dictate the legal parameters for that inspector when they arrive. If they came out in pre-COVID to check on a lockout tagout procedure for a machine, their jurisdictional scope is limited to that. So they would just go to that machine. They couldn't do a wall-to-wall inspection. So in the era of COVID, it's very important to understand whether it's a complaint-based inspection, a fatality, a hospitalization, so you understand what you're working with and where you can allow the inspector to access inside your facility. Really important, it sounds simple, get the phone number and email of the inspector. Oftentimes I have clients that say, I don't know who I talked to, I don't know who showed up. So then when they engage me to try to work it out with the inspector, I don't even know who I have to go to. Make sure you have that information. Again, like I said, talking about the scope of the inspection, only grant access that matches the scope, and make sure you walk around with the inspector during the site walk. If they take pictures, you take pictures. You have to have a match for everything that they have, because that's the evidence that they're going to try to use against you. If they request documents, make sure you understand why they're requesting it and what the timeline for that request is. It's really important to know what events are coming up. So ask questions. Say, hey, what's going to happen next? Are you going to come back? Who do I talk to if I can't get a hold of you? These people are just trying to do their job, but I found that if you're friendly with them and you're cordial with them, you have way better results. Next slide, please, Hallie. So the risk of non-compliance, obviously, the failure to comply with state and local DPH requirements and OSHA regulations will likely result in employee complaints, which could then result in an OSHA inspection or an inspection by the local health department. Then there are the DPH citations. DPH will show up if your worksite triggers an outbreak, and that's determined by local regulations. So in some counties, it's 2 positive cases in 14 days. Other counties, it's 3 positive in 14 days. You have to self-report. There are requirements to report when you trigger outbreaks. So that means that you're the one telling the DPH to come to your facility, but in a way, then you can be prepared for that. Again, like I said before, work with the inspectors. That's the best way to move forward. Labor code violations, for instance, in California, AB 685 was codified as Labor Code Section 6409.6. And you can get hit under that for failure to notify employees and subcontractors at the work site when there are positive cases. DPH citations, like I said, that usually occurs only if there's an on-site inspection and the inspector actually witnesses a violation, like someone who doesn't have their mask on, who isn't social distancing. The fees are not great, but the problem with that is that it keeps the inspectors coming back. Wrongful death claims, those are, very rare. It requires extreme negligence. Most of what we're dealing with here is going to be covered under workers' compensation liability. Again, of course, we have increased workers' comp claims in places like California with Senate Bill 1159. It imposes a presumption of workplace transmission. So employers are required to report every single COVID case, even if contact tracing evidences that it wasn't a work-related transmission. Still, you got to do it. The workers' comp carrier is going to go ahead, do their own determination and investigation, and move on. The last 2 things that are super important: loss of productivity and bad morale. I mean, when employees aren't happy, they're going to be more likely to report safety and health violations to OSHA and the DPH. Amazon's situation gained a lot of visibility in New York as a result of workers speaking out against the company, and they felt like the company wasn't listening to them. So it's really important to let your workers know that you care about their well-being and follow safety regulations and requirements. And that ends my section. So I'm going to turn it back over to Phil, who's going to hit discrimination issues along with Devjani and Phil.
Okay, thank you. That was fantastic, Melissa. Thank you. And I have to say, I'm going to just, we have done an amazing job so far. We have a little more than 15 minutes left. We are going to cover some of the discrimination issues that Johnny has mentioned, many of them, but we do want to leave time for questions. You know, you can post them on the chat, I guess, and we'd love to hear them. So, or the Q&A. So please do feel free to ask some questions. You know, I just do want to emphasize the need for communication is key. I think everyone has emphasized it. It's, you know, if you're complying with the law, that's great, but let your employees know that you care about them. Let them know that their health is your first priority. Obviously, your deeds have to match your words, but keep in touch with them and, you know, just keep their best interests in mind and let them know that your decisions are based on that. Hallie, let's go to the next slide. Devjani mentioned the EEOC guidelines. Here's a site to them. And by the way, let me mention Littler's webpage, which Devjani also mentioned, really is extraordinary, the public-facing webpage. We have so much information on that webpage that we have developed as a firm, and also we've gathered a lot of public information. The EEOC guidance is actually quite helpful. It makes clear, of course, that discrimination laws do apply in the course of this whole pandemic, but it also makes clear some of the, I don't want to say leeway, but the legitimate concerns that employers have in terms of being sure that their employees can work in a safe environment. And so, you know, doing things like requiring temperature checks, doing things like, you know, requiring that people not be sick when they come to work, while emphasizing the obligation to make reasonable accommodations. Nevertheless, the EEOC guidance answers a lot of questions that you might have. I think also what's very impressive is that the EEOC guidance highlights front and center the discrimination that has been occurring against people of Asian background, Chinese in particular, which is of course horrendous and just you know, there's a whole list of bad words for what has happened, and I'm glad that it's on the government's radar and that it will not be tolerated. I want to mention that a lot of the EEOC guidelines focus on the issues concerning harmonizing possible discrimination on the basis of disability or religion, so that, you know, people may come forward and say, I don't want to take a vaccine because of my religion or because of my disability, and it talks to those issues and how do you deal with those issues as an employer. And also it deals with things like if employees are sick, that they might their presence might constitute a direct threat to the health and safety, not only of themselves, but also other employees. And so it talks clearly, the guidelines speak to those issues. The guidelines also, of course, as I point out here, make clear the confidential nature of medical records and the importance of keeping them separate. And a lot of these test results and so forth may constitute medical records. Let's go to the next slide, Hallie. I'm not going to touch on everything in these guidelines. I just want to highlight a few things because you really can read through them. But you'll see they talk about how employers can measure employees' body temperature or require that they get their temperature measured. They can administer COVID-19 tests. But they also, the guidelines emphasize the risk of relying on stereotypes in making these decisions or declining to hire people. So the mere fact that you may be on a CDC protected list of people who may be more susceptible to the virus doesn't mean that you can treat those people differently in terms of discriminating against them. And so that's an important thing to keep in mind. Next page, please. one thing that comes up a lot is we get employees who say, I'm afraid I'm going to get sick. I've got a member of my family. I don't want them to get sick. I don't want to come to the office because I don't want to ride the subway. Obviously, those are things that we have to deal with in a sensitive and a sensible way. But the laws that prohibit discrimination generally do not apply to people who do not have a disability. And so those kinds of excuses generally are not something that require an employer to accommodate. However, there may be instances where someone's fear may be a result of, some kind of disorder, stress disorder, or something that may actually be a diagnosable condition. And so there are going to be situations where people may need to deal with these situations, and it's a case-by-case analysis. It should not be left in the hands of managers. It should be dealt with by HR in consultation with counsel. By the way, it's also important to remember, again, that under New York and federal law and the laws of most states, there is an obligation to engage in a constructive dialogue with individuals who claim that they have a disability and that the disability prevents them from being able to perform the essential functions of their job. This constructive dialogue in New York must actually be in writing. There has to be a written record of the fact that you had this dialogue. Any accommodation that you make should be put in writing, and any accommodation you decline to make needs to be put in writing. And so the whole process, it's just smart to document the entire process, not just deal with it by saying yes or no, you can or you can't do it. And again, counsel can also often assist with this documentation. Next slide, please. The guidelines talk about direct threat assessments. I spoke about them a moment ago. There may be situations where you're going to have the right to request the employee to get more information for you from their doctor. Again, those kinds of queries are very regulated, highly regulated by the Americans with Disabilities Act and the FMLA, the Family Medical Leave Act. So before doing that, you need to really understand what you can and cannot do. But there may be occasions where you can request more information from the doctor before you make a decision on reasonable accommodation. Next slide, please. Here we talk about, again, the guidelines talk about the interactive process, the cooperative dialogue. I mentioned at the bottom. Again, reading these guidelines can be very helpful. Next page, please. I think that as Devjani mentioned, perhaps the most significant outcome of the pandemic may be that going forward, it's going to be more difficult, at least from a most significant outcome from a disability discrimination law perspective. It's going to be more difficult to tell employees, you know what, we can't accommodate your request to work from home. We now all see that it kind of works, and in many, many cases. We are not getting much in the way of questions. It would be great if you should feel free to raise your hand and ask one. Let's go to the next slide. Reasonable accommodations. Other kinds of reasonable accommodation that we may have to think about is a leave of absence. I've got a matter now where we've got somebody on a leave. Their doctor asserted that they required a leave because of, not because they had the COVID presently, but because of symptoms that have persisted after COVID was over. And so we did request more information and we granted the leave. Next slide, please. This is self-explanatory in terms of applicant screening upon hire. And the next slide, please, is also, as I mentioned, self-explanatory, and the idea that we can't discriminate against people based upon their national origin, as well as their religion, as well as their age, as well as their disability. There was a question before about, can someone make me get the vaccine? I think that Devjani covered that. There may be circumstances where an employer I think that her she made it clear that there are circumstances where the employer can, but the guidelines make very clear as well that if an individual feels that they cannot because of a disability or because of a legitimate religious belief, then there may be circumstances where we have to at least consider the possibility of a reasonable accommodation. But there may be circumstances where we simply cannot accommodate because of the potential that they're going to cause a threat to the health and safety of others. There is a question up. If I'm eligible for a vaccine before all of my colleagues, do I have to disclose why I was eligible, or is this none of my employer's business? Devjani, would you like to take that?
Sure. You know, there are a lot of questions. There's almost as many questions about who can ask whether you've gotten a vaccine as there are about getting the vaccine itself. And so the important thing to keep in mind is that a lot of the reasons why someone could be eligible for the vaccine are things that employers generally should not be talking about, right? We generally know you don't ask how old someone is, you don't ask about their family planning considerations, you don't ask about their medical conditions, but these happen to be the reasons why somebody might or might not get the vaccine. So, you know, it can be a little confusing. A lot of people, when they get the vaccine, are choosing to let people know, hey, I got the vaccine, here's a picture of me getting my shot. But no, unless an employer is mandating the vaccine, and even in that case, only limited people within the employer can be getting the information about who's gotten it. No one should be required to disclose what the reason is. You know, if you got it because you have a medical reason, if you got it because of age, if you got it, you know, for some other reason, you're not required to disclose that. If you're an employer and you're thinking about collecting proof of the vaccination, you want to make sure that that is tied to some specific reason, whether it is so that you can assess safety, whether it's because you're in a state like New York where you're required to pay people for the time. But again, this is not a situation where managers should be walking around asking people, have you been vaccinated? If so, why? If not, why not? All of that can lead to the issues that Phil is talking about in terms of discrimination. We don't want to generally open up the door to people intruding on each other. I see another question in the chat about the vaccine, which is about side effects. What if people get ill from side effects? This is something where, you know, we want to make sure that we distinguish between anecdotes and data, right? There's more data by the week in terms of you know, actual published studies in science, because at this point, hundreds of thousands and even millions of people around the world have gotten at least one dose of the vaccine. There are some cases in which people are experiencing side effects, and there are methods of dealing with this, right? There's sick leave. Employers should also look at providing sick leave if it's not something they provide otherwise, to enable people to recover from side effects. But generally speaking, you know, at the point where you're getting the vaccine, that is something you can address with either your own doctor or the person who's giving you the vaccine in terms of what you can expect and what you should do. There is a program, a safe harbor program for people getting the vaccine in terms of any, you know, adverse effects that you might have, and that's something that you get information about at the time that you get the vaccine. But generally, what we've seen after, you know, tens and hundreds of thousands of people getting it is that there have been relatively few side effects, and they've been pretty temporary. So, you know, this is something that really we should be looking forward to and encouraging people to do.
Mm-hmm. You know, I want to just mention one question that has been answered, Johnny, that you kindly answered on the chat. But someone asks, for employees who move to a new address during their time working from home, can the employer approve where they do their work remotely? And this is actually an issue that is coming up quite a bit in different ways. First of all, we are seeing people moving to, say, California or to just a completely different location and without telling their employer. And, you know, generally speaking, the employer can require that you be within a certain distance of the office, because the employer may require, for example, that you have to come to work for a certain number of days a week. This is, and if you are in a different state, you may have to quarantine before you can go back to work. And so we are seeing a lot of issues with employees working in different states. Other issues that you have to consider and think about are tax issues. How are you withholding taxes in the state in which they are residing? Are they residing in that state now that they've moved there? There may be tax and other and related issues concerning individuals who move. And the other thing we're seeing, kind of on the flip side of that, is a lot of employers deciding, hey, you know what, this really is working, and maybe we'll think about hiring a whole bunch of people to work remotely, and how do we go about doing that? And so we are getting a lot of questions from employers who are saying, how do I open up? How do I decide that I want to hire 100 people in Texas, where we don't have an office? And so there are a lot of regulatory issues that surround that, depending on what business you're in. Again, you may have to register as a business in that state. You may have to register to get payroll handled in that state. You may have to register to do business in that state. And so there are a number of issues that are raised by that. Johnny, I don't know if you've noticed, I see another question in terms about COVID symptoms.
Yep, I
Maybe you want to read it and
do see
respond?
that. So there's a question about asking job candidates if they've tested positive or been diagnosed with COVID-19. So this is something you want to be careful about. If what you're doing is you're having an on-site interview and you are simply asking people about the last 14 days, that is, are you currently symptomatic for COVID? Have you, been in close contact with anyone? You can certainly let candidates know ahead of time if you are interviewing them in person on your site that they're going to be asked these questions. It may be a lot of employers are really doing those initial screening interviews by Zoom, to be honest, because interviews are something that can be done by Zoom, whereas in person, you might have to have people wearing masks. That might be a weird way to do an interview. I would be very careful not to just ask people the question generally about whether they've ever tested positive or been diagnosed with COVID, because that's not really something that ties to anything about the job. So if it's an issue of assessing current safety, that is, should this person be out and about and interviewing with you today, that's one thing, that's site safety. If it's a general question, about ever, I would not ask that question because it doesn't really go to anything about the job. And certainly in some parts of the country, we expect a lot of people could have had COVID, and there isn't any stigma about it. This is a pandemic. So tread carefully there.
Yeah, we are at 3:14, and actually there's one more question. Is it legal to get employees coming in office tested weekly? And the answer, I think the answer is yes. I don't think there's any reason why you could not.
It is yes. I think the big issue there is just going to be practical, right? Because one, it takes a while. Those tests cost money. They're expensive. It takes time to get the results back. And as Melissa mentioned, there are a number of places where if you're testing people, you're going to then have reporting requirements. So you're going to be the one who needs to report to the Department of Health. We have employees who tested positive. There's also going to be states like New York and elsewhere where if the person reports to work and they're ready to work, and then you test them positive, you're going to have to pay them. That doesn't mean that you shouldn't do it or you shouldn't send them home, but you just have to build a testing program that accounts for all of this, which is something we've done for clients. So, there's not a legal reason, but there are a bunch of practical things that you have to put into place to do that compliantly. And if you do it on site, I don't know if Melissa's technology is working, but she would tell you if you do it on site, you are creating health screening records that you potentially have to keep for 30 years under the OSHA requirements, right, Melissa?
That's right. Can you hear me, Dev?
Yes, I can.
Yes.
Okay, great. All right. Yes, and the other issue really is, that's right, if it's on site, you're going to fall under the medical records retention requirements of OSHA, which were not designed for these purposes. They were really designed for long-term development of diseases like related to asbestos exposure, but here we find ourselves having to comply with these requirements that exist So there's problems with that. And then also the other issue, the clients that I've been working with, certainly in California, where testing is mandated, is they cannot get anyone to come on site to do the testing. So employers that have very large employee populations at certain facilities or all facilities are unable to find a service to come on site and conduct the testing. Another client I was working with actually finally got a vendor lined up, but the vendor is now saying every time the site needs to have the testing implemented, of course, because it's only mandatory if you trigger certain requirements or certain numbers, it's going to take 4 weeks of lead time, which almost in effect, flouts the entire purpose of what they're required to do under the ETS, because you have to test within the first 2 weeks. So, I mean, logistics are a real issue with that. So I would recommend looking into it if you're considering on-site.
So I think that we are officially out of time. I know that, and if you have more questions, of course, please feel free to reach out to us directly or reach out to the chamber and they can put you in touch with us.